A warm welcome to the program. I am Mary Kanu. Now, amid the lingering controversy over the judgment of the Presidential Elections Petitions Tribunal, the presidential candidate of the Labour Party in the February 25 general election, Peter Obi, has filed 51 grounds of appeal before the Supreme Court, seeking the nullification of judgment of the Presidential Election Petition Court and the election of President Bola Tinubu. The presidential candidate of the People's Democratic Party, Atiku Abubakar, had similarly filed his appeal to challenge the PEPC's verdict delivered on September 6. The appellants had 14 days from the date of judgment to file their appeal to challenge the verdict at the Supreme Court. Now, the 14-day period ends on Wednesday. Obi and Atiku had filed separate petitions at the PEPC accusing Nigeria's electoral umpire, the Independent National Electoral Commission, and President Bola Tinubu of electoral malpractices. They contested Tinubu's qualification to stand for election and begged the court to set aside the election, but the court in its decision held that they failed to substantiate their claims of electoral fraud against INEC and the president. Now, in his notice of appeal, Obi and his party's team of lawyers, led by Senior Advocate of Nigeria, Levi Uzoko, said the Presidential Election Petitions Court erred in law and thereby reached a wrong conclusion when it dismissed the petition lodged to challenge the outcome of the presidential election. This move has ignited discussions and debates across the nation. And joining me to discuss this is legal expert Evans Ofeli. Thank you so much for joining me on the program. Now, from a legal perspective, what are the key arguments or legal grounds presented in the new petitions, filed by Peter Obi and Atiku, and how do they compare to previous legal challenges related to the election?
All right. The appeal brought before the Supreme Court on the fallout of the judgment from the Presidential Tribunal. The two major contestants to satisfy, that is the APC, the Labour Party and the PDP. Now, the PDP have filed their appeal, and we have seen the grounds of appeal they have raised, that the court erred in law to have reached the conclusion that President Tinubu actually won the elections, that the issues of qualifications were not properly addressed by the tribunal, and the issues of the president's certificate from the university he alleged to have attended are part of the issues on the grounds of appeal that were brought forth, that he was not qualified for that position and that they lied on that oath to have attended that school and did not attend it. So now they want the Supreme Court to look into that area. And like we all know, that has been the reason why they brought a suit before against the school in the United States, asking that the school provide those documents and the rest of that. And with the issue of irregularities during the election, the issue of the fact that INEC did not upload the results as it should have done, were also brought as grounds of appeal that since the innovation in the Electoral Act were that it was expected to enhance transparency, and because that was not actually incorporated, they have brought that as a ground of appeal in the question on that reference. The 25%, of Abuja, which has been a contention, which the tribunal ruled that Abuja have no special status, was also part of the grounds of appeal they have brought.
Now, for our viewers who may not, be familiar with the country's legal system, can you walk us through the process that this appeal will undergo in the Supreme Court?
Yeah, what the appeal will undergo at the Supreme Court is that it's going to be considered, it's going to be heard. Usually on appeal, you cannot introduce new matters. You can only concentrate on what has been argued already at the Court of Appeal, at the tribunal. You cannot begin to bring up fresh issues. The Supreme Court will not dive into fresh issues. The Supreme Court will not descend into the arena of conflict. The Supreme Court will remain an umpire in the case and look at it dispassionately. Areas where the Court of Appeal erred, the Supreme Court will make a pronouncement to that effect, either to upturn the judgment or to uphold it. Those are the two options. Of course, the appellants will be asking that the court, should upturn the judgment or the verdict of the tribunal, and then the respondent to be saying that it should be upheld, that the decisions reached by the tribunal is right and proper under the law and should be upheld to that effect. So those are the issues that they're going to be contending at that court. So the Supreme Court, the standard is that both sides will file their processes, okay, to bring their appeal, transmit records of appeal, wherein all the documents tendered at the tribunal will be put together for the Supreme Court to see, and parties will write their appellate brief to that effect.
So what then are the potential timelines, for the Supreme Court to review and make a decision on these petitions?
The timeline is 60 days. The court have just 2 months. Supreme Court have 2 months within which to determine the case from the date the matter commences. From the date the matter commences. So it is expected that counting from the day the matter commences, within 60 days from that day, the court will give its decision. And may I let the public know that the court will not pander towards social media expectations or public expectations. The law is the law, okay? Application of law is for the purposes of justice. The doctrine of equity, the common law, and all the principles of law put together is for the advancement of the justice of the case and for the well-being of society. I would therefore state that the public must, as a matter of necessity, trust the court enough to do justice, because that is what it is meant to do. Threatening judges or their families or using social media to blackmail and threaten the judicial system or the judiciary will lead the society nowhere.
So we cannot take away the fact that the judiciary is crucial in this appeal. So how then can the judiciary ensure a fair and transparent resolution of this case, since both parties, feel that the appeal court did not deliver a justified decision?
Well, that's what I was saying. The Supreme Court they're going to look at all the issues again. They are going to look at all the issues as they were discussed, or as you remember that the judgment will also be front-loaded. So the Supreme Court will look at the issue, look at the judgment, and do its own analysis and appraisal of what the the tribunal did. You understand? So it's going to do its own appraisal, a fresh appraisal that is dispassionate, that may not necessarily be in tune with what was done at the Court of Appeal, okay? As a final court in the land, it has that powers, okay, to look at the Court of Appeals or the tribunal judgment and either affirm it or upturn it, okay? Can either uphold it or upturn it. So that is the law. But the Supreme Court will not affirm or uphold it without reasons. Not without reasons. It will do that with reasons that are law-based, okay, that is based on law. And the Supreme Court will act in that direction to ensure that the destination is justice, okay? To ensure that the destination is justice. When when the public go through the Supreme Court judgment, they will find the reasons and the reasoning of the Supreme Court to that effect, whichever way it goes. Nobody can sit here and predict how it's going to go until um, parties have made their case and until the time within which to dispense of this case and lapse.
All right, now, so finally, before I let you go, what are the potential outcomes of this appeal and how might they, impact the political landscape in Nigeria?
Well, it will affect the political landscape of Nigeria in a way that the legal team of both sides I think, will learn. It will push the knowledge of law further. Okay, it does not mean the outcome will now make it to mean that parties will not want to go to Supreme Court again. No, you understand? There are no two cases that are the same. Today, we are at the Supreme Court ventilating on issues of qualifications, disqualification, 25%, fraudulent misrepresentation, and the rest of that. You are ventilating that. In case we may come in the future where the issues may not even be any of the aforementioned, it might be a different set of things that have been argued at the court of first instance, and now they are now at the Supreme Court. So there is no way it's going to affect the political landscape just like it has done in the past. This issue of 25%, we had that issue even during the 1979 election in Nigeria, where you have Shagari and Awolowo in those days. Okay, down to today, we're talking about part of it. So the precedents that will come out of this will be linked to precedents that have already been made before now.
All right, now, our legal expert, Evans Ofeli, thank you so much for your time and your contribution. Thank you.
All right.
All right, we'll take a break now, but the conversation will continue when we return. Join us again. Welcome back. The lingering controversy over the judgment of the Presidential Election Petitions Tribunal and the appeals filed by the presidential candidates of the Labour Party, Peter Obi, and the People's Democratic Party, Atiku Abubakar, has been a focus on the program for today. We are joined now by legal expert Monday Obani. Thank you so much for your time. Now, could you provide us an overview of the 51 grounds of appeal filed by Peter Obi in response, to the tribunal's decision?
Yes, thank you very much for having me. I've heard about 51 grounds of appeal, meaning they have a big hole 51 times from the judgment of the Court of Appeal sitting as a tribunal. Now, most of them borders on misdirection of law according to them, misapplication of law, wrong evaluation of facts, and mainly, I'm sure of this issue of Abuja, Federal Capital Territory, as one of the grounds of appeal, and at the same time, the issue of being a convict, that was brushed aside by the tribunal, by the Court of Appeal. These are some of those grounds that they felt that they have not gotten sufficient justice, or that the court has not done sufficient justice about those decisions, and they will want the Supreme Court to take a second look at it again, and then probably give them justice. Because when you appeal, you are asking the Superior Court to review what was the ratio, what was the decision of the court below. You are asking that you are feeling dissatisfied with the reasoning of the court or with the evaluation of the evidence by the court, or that the court has misapplied law or has not been able to evaluate the facts accurately. These are some of the grievances that will make you to go, to the Court of Appeal, to a higher court in order for a review to be done by that court. So what is going on now is that those petitioners, both Peter Obi and Atiku, Abubakar Atiku, they are feeling very dissatisfied with the decision of the Court of Appeal, and they have now approached the Supreme Court, and they have pointed out several grounds of notice of appeal. Several grounds of appeal. So the court will look at it and know whether those grounds were justified, by the appellants.
Well, the rejection, of these petitions carries both legal and political implications. So, what impact, might this, or would you say this will have on the political landscape in the country?
Now, the issue of jurisprudence, establishing this jurisprudence is very important with any matter that you have brought before the court. I mean, having the final court to make certain pronouncement, because if you leave it at the Court of Appeal, it remains and it becomes binding, especially those decisions that you disagree with. But taking it up higher to the Supreme Court will mean that the Supreme Court will have the final say. It will be very difficult at this juncture for anyone to make a very specific pronouncement saying that the Supreme Court will invalidate the election of President Tinubu, because there are other considerations that come in apart from legal. You have to look at the issue of political implication. You have to look at, and that is the fact. You have to look at the cost. If you're asking for another election to be held and all that, who bears the cost and all that? You also have to look into the issue of stability of the country. You see what is happening in the West African region, where there is a military coup here and there are a lot of instability within the African continent. So the stability of a country, is also very key and uppermost in the mind of justices of the court. So it may not necessarily be to invalidate, but to strengthen some of the legal precedent, that the Court of Appeal, if you leave it at that point, will become established and may not necessarily augur well for the electoral processes and judicial adjudication. So there must be a strengthening of some of the points that they feel aggrieved by. That's why they are proceeding before the Supreme Court. Now, the politics of inclusion is very key. I mean, winner takes all. Takes it all has not been very helpful for us as a country. So, in running an inclusive government and making everyone to be involved can give a sense of belonging and make everyone to contribute his or her own quota towards national development. It's a very good one if that is pursued and become very, very priority and policy of the government. But then the issue of pronouncement of law is something also we have to develop. And that's why you see people always go as far as going to Supreme Court for final decision on any matter they feel should be pronounced by that court. So I don't see anything that is actually a distraction or a disturbance to taking this matter before the upper court for at least final pronouncement on some of the decisions that have been taken. Because if it's left at that level, there are this issue of burden that has been placed on the petitioner, and no petitioner will be in a position to actually discharge that burden. If we leave it the way it has been pronounced by the Court of Appeal, it will be a very onerous burden that no petitioner will ever succeed, improving any election petition in Nigeria, if that decision is allowed to stand. So, because the Electoral Act itself has modified some of those decisions, like issue of documentary evidence now, when you bring it and tender it at the bar through any other third party who may not necessarily be the maker, the new Electoral Act says it cannot be regarded as dumping. The court is enjoined to look at that documentary evidence. So you don't need to gather all the polling unit agents, all across from across the country to prove a petition in the light of some of this innovation that has been done by the Electoral Act. But decision of the court, is still taking us back to 2007 and 2010 before this amendment that has actually created those innovations. So I think that going to Supreme Court for a final pronouncement, a final judicial precedent to be established, strengthening our legal processes and our judicial process, including the electoral processes, is something that may have probably, really happened and happen on their mind that is making them to go all the way to Supreme Court. And I don't think there is anything wrong in doing that. But I doubt whether the Supreme Court will clearly invalidate any election that has already been concluded and announcement made.
Well, we can both agree that there is political tension in the country. So how can Nigerian leaders and also citizens, prioritize unity and national interest?
The position is that politicians don't have enemy. There is no political enemy in Nigeria. No, I mean, I'm talking about among politicians. It's only about interest. These people, you think that they are enemies. They're not. You see them, Tinubu and Atiku, anywhere they see, they hug themselves, and they meet and talk. The same thing with P2B. P2B was in somebody's wedding recently in the north. And so it is not the followers most of the time that think there is enmity among this. No, they you go to court against an opponent, who has won an election does not in any way depict enmity. It's only those who are primitive in mind that will think that is no. You are trying to probably feel that you have a right, and this right, if it is not properly, given to you, you have a right to challenge it, and not instead of using gun, instead of using knife in order to pursue your right, you go through the process of court in order to, let a third party that is clearly impartial hear you, and then be able to give you justice, in the manner the court feels is right. But if there is no justice given, if the laws are not right for you, then you may not get whatever you think is justice. So that is the proper thing to do. So I don't see it as enmity. I don't see it as any problem at all. I don't even see it as, creating a crisis. No, going to court is a normal thing that is being done, in order to assert your right, So to me, if anyone thinks that if I take you to court or I speak against some certain things you do and all that, that is enmity. I don't think that is the right thing to do, because the law itself has given every person right. When you feel that you are aggrieved over certain things, you have a right to approach the court in order to make a specific pronouncement, which is what P2B and Atiku. If anyone thinks that P2B and Atiku is an enemy to President Tinubu, they're making a mistake, because most of them know where they meet, and then they are all fighting for the interests of this nation, one way or the other. So I don't think once you see it in that light of being enemies and all that, or that the person is creating crisis. Oh, why don't you go and relax? Why don't you allow the listen to fly or whatever? If you do that, you are getting no. It is only the followers. The politicians themselves don't see anyone taking them to court as creating enmity. They don't see it that way.
All right. Well, finally, what are the possible options for Atiku Abubakar and Peter Obi, moving forward, and how might this decision, shape their political careers?
The position is that if the Supreme Court makes a final pronouncement as to what has been decided by the lower court, they have no other choice than to abide by the decision of the Supreme Court. That is what I expect them to do, and then re-strategize towards the next election, whether they want to contest. And if they don't want to contest, who are they going to support? Or would they now probably jump over to APC and be a member of APC and all that? That is clearly left, in their hands to decide. I don't have the capacity to advise them what to do, but they should be able to know after that decision. But the only thing I will only advise is that they should maintain peace, because Nigeria is a very big country and want Nigeria to succeed. And whatever they are doing is towards ensuring national development and cohesion. So anything that will bring cohesion, anything that will bring peace, anything that will bring development, anything, because and you can't even develop without peace. So anything that can ensure peace and ensure peace, they should pursue it, and then strategize for next election if they want to contest, and then gather their followers, and then start playing an opposition if they want to against the current political party. Wherever APC make a mistake, they should be in a position to criticize and correct them, and probably offer an alternative in case of in the next 4 years. So that would be my advice to them.
Right. Legal expert Monday Obani, thank you so much for your time and your insight. Now that's how much we can take on this edition of the program. Thank you so much for joining us. I am Mary Kanu. Bye for now.